A CEO asked ChatGPT how to void a $250 million contract. The judge read his chat logs in open court. He lost his case. His company lost the lawsuit. The founders just got their money back and their company. This is the most expensive prompt ever written. If you build with AI, this is not the story you think it is. Every other video on this case is going to tell you the same lazy take that ChatGPT made stuff up, that AI is dangerous, that you shouldn't trust a chatbot for big decisions. That's not what happened. The model didn't hallucinate. ChatGPT gave generally reasonable strategic advice. The advice that ended up in a Delaware courtroom is the kind of outline a junior consultant might have written on a whiteboard. The failure wasn't the model, the failure was the human at the keyboard. So here's what we're actually going to do. We're going to walk through exactly what the CEO of a multi billion dollar gaming company asked a chatbot, what the chatbot said, what he did with that answer, and how a court used his own prompts as evidence against him. And by the end, you'll have a 4-question test you can run before acting on any AI output that touches money, contracts, or anything you can't easily reverse. The same test that, if Krafton had used it, would have saved them $250 million. Let's set the table. Unknown worlds. Entertainment is a small studio that made a game called Subnautica, an underwater survival game on an alien planet. It is one of those quiet, slow burn hits that just keeps selling. 17.5 million copies. Over $300 million in gross revenue. Genuinely evergreen. In 2021, a South Korean publisher called Krafton, the company behind PUBG, bought Unknown Worlds outright. $500 million upfront, plus another $250 million in earnout payments tied to future revenue. The earnout math is worth understanding because it's the whole motive for what comes next. The earnout doesn't pay anything until Unknown Worlds clears about 70 million in qualifying revenue. After that threshold, every additional dollar of revenue triggers $3.12 of earnout, all the way up to the 250 million cap. It's leveraged. A modestly successful sequel triggers a massive payout. Now, the piece every other video skips. Krafton didn't just buy the studio. They contractually guaranteed that the 3 founders, Charlie Cleveland, Max McGuire, and CEO Ted Gill, would keep operational control of Unknown Worlds, and they could only be fired for cause. Specific cause. Felony, gross misconduct, fraud. Not we changed our minds. Not it's getting expensive. Cause. The founders had leverage going into that deal. They had over 30 acquirers interested. They didn't need to sell, so they negotiated for autonomy. And Krafton signed it. Here's where the trap closes. Subnautica 2 is the sequel to one of the best-selling underwater games ever made. The internal projections at Unknown Worlds were strong. Strong enough that the earnout was about to trigger easily. Suddenly, the Krafton CEO, Chang-Han Kim, started doing the math. $250 million was about to leave the building. Going to the founders, he was contractually required to leave in charge. And in his own private communications, he started referring to the deal he had personally signed as a, quote, pushover contract. That's not my word. That's the word the Vice Chancellor of the Delaware Court of Chancery quoted directly in her opinion. Read it on the screen. Quote, fearing he had agreed to a pushover contract, Krafton's CEO consulted an artificial intelligence chatbot to contrive a corporate takeover strategy. End quote. Take a second on that sentence. The Vice Chancellor of one of the most respected business courts in the world wrote, in a published opinion that lawyers will be citing for the next 20 years, that the CEO of a publicly traded gaming conglomerate consulted a chatbot to plan a corporate takeover. That sentence is now case law. Okay. So, what did he actually ask ChatGPT? And what did ChatGPT actually say? He didn't ask, is this legal? He didn't ask, what would a Delaware court think? He asked effectively, how do I take this company back without paying out the earnout? And ChatGPT, being ChatGPT, gave him a structured answer. The advice clustered around 5 moves. 1. Set up an internal task force to delay or block the release of Subnautica 2. 2. Use Krafton's control of the publishing platform to lock the studio out of shipping their own game. 3. Reframe the public narrative. Don't say this is about money. Say it's about quality. Say it's about protecting fan trust. 4. Start preparing legal cover around lack of game readiness. 5. Draft a public statement to control the press cycle. Now read those 5 moves again, slowly, and ask yourself something. Is any of that, taken in isolation, insane? No, it's recognizable. A junior consultant might write that exact bullet list. A bad junior consultant, but a real one. And that is the trap. The advice was structurally fine. The advice was tactically dangerous. And the difference between those two things is what every operator who builds with AI needs to internalize. Because the CEO didn't see the difference. He saw a plan. He printed it. He acted on it. And he did it without showing it to a single Delaware lawyer. Let's do the honest analyst's breakdown. Where did ChatGPT actually get this right? And where did it whiff? What it got right. The bones of a takeover playbook are recognizable. Identify your levers. Sequence your moves. Control the narrative. Prepare your legal cover. That's M&A litigation strategy day 1 stuff. The model wasn't wrong about the shape of the answer. What it didn't even attempt, and this is the whole game, falls into 4 buckets. It had no jurisdiction awareness. The Delaware Court of Chancery is the most sophisticated business court on earth. It is famously, almost personally, hostile to bad faith earnout interference. Every single move the chatbot suggested was textbook, what not to do under Delaware law. The model didn't know it was playing in Delaware because nobody told it. It did not stress test the answer adversarially. There's no version of what does opposing counsel do with this in discovery. There's no version of what does this look like when subpoenaed. There's no red team. The model gave a confident answer and stopped. It assumed a human verification layer. ChatGPT does not believe it is the final decision maker. It generates a draft. The CEO turned the draft into a directive. The model never said do this. The CEO never asked anyone whether to do it. And the one I find most damning, the model had no concept of future visibility. Nothing in the chat warned that this transcript could end up as a piece of trial evidence. Because that's not the model's job, that's the operator's job. And the operator forgot. So Krafton ran the playbook. They locked Unknown Worlds out of its own publishing infrastructure. The studio could not ship the game it built. Then Krafton, without authorization, posted critical messages on Unknown World's own website. And then they fired all 3 founders. The stated reason was, quote, a purported lack of game readiness. Then Fortis Advisors, representing the former shareholders, sued. And here is where it gets really bad for Krafton. Mid litigation, they changed their story. They dropped the game readiness argument. Instead, they claimed the founders had secretly entered semi retirement and that all 3 executives had executed, quote, massive downloads of company data. The court was not impressed. The vice chancellor wrote, and this is in the opinion you can pull up right now, that, Quote, Krafton's newly manufactured justifications for the terminations are pretextual. End quote. That word, pretextual, is judge speak for you, made this up after the fact, and we know it. On the data downloads, the court found that the founders were not exfiltrating anything. They were defending the studio's own work product during what the court described as Krafton's takeover attempt. They kept the data confidential. They returned it. There was no breach. Every single fig leaf Krafton tried to put up, the court burned. March 16th, 2026. Vice Chancellor Lori Will issues her opinion. Three things happen. 1. Ted Gill is reinstated as CEO of Unknown Worlds, with, in the court's exact words, full operational authority over the studio. He decides when Subnautica 2 ships. Krafton does not. 2. The earnout clock gets reset. The court ruled that the earnout period would be, quote, equitably extended by the duration of Gill's ouster. Plain English. Krafton tried to run out the clock. The court added that time back. The $250 million Krafton was trying to escape is now squarely back on the table. 3. Money damage on top of all of this are reserved for the second phase of the litigation, meaning Krafton may also have to pay for the harm caused by what they tried to do. Pause on that. The CEO of Krafton consulted an AI chatbot to avoid paying an earnout. The chatbot's strategy got executed. The strategy got litigated. The litigation got published. The earnout, the one thing he was trying to avoid, is now larger than it was when he started. The founders are back in charge, and his own chat transcripts are in the public record. That is $250 million of negative ROI on a single conversation with a free tier chatbot. Hence the title of this video. This is not a one-off. There is a pattern, and once you see it, you'll see it everywhere. 2023. Mata versus Avianca. A lawyer used ChatGPT to do case research. ChatGPT cheerfully invented 6 prior cases. Names, citations, judges, the works. The lawyer filed those cases in federal court. The lawyer got sanctioned. The case became the canonical example for an entire industry. 2024. Air Canada's customer service chatbot invented a bereavement fare refund policy that did not exist. A passenger relied on it. Air Canada argued they shouldn't be bound by what the bot said. The tribunal disagreed. The airline paid. 2025. The MyPillow legal team filed a brief with quotes and citations that turned out to be hallucinated by an LLM. They got fined. They are not the last firm this will happen to. The pattern is the same in all 4 of these: the Avianca case, the Air Canada chatbot, the MyPillow brief, and now Krafton. A human being treated an LLM's draft as a final answer in a domain with adversarial verification. Court, contract, regulator, earnout. Anywhere there is an opposing party who is paid to look at your work and find the holes. That is exactly where you cannot afford to skip the human review layer. So, if you build with AI or you make decisions with it, here is the test. Memorize this. Run it before any AI output touches anything you cannot easily undo. Question 1. Adversarial. If a hostile expert read this answer, what would they tear apart first? If you can't list 3 plausible failure modes in 30 seconds, you are not ready to act on this output. You're ready to ask it more questions. Big difference. Question 2. The jurisdiction. Does this advice account for the actual rules of the game you're playing? Legal jurisdiction, regulatory regime, specific contract clauses, internal politics. The model has no idea what game you are in unless you tell it. And even when you tell it, it forgets faster than you do. Question 3. Verification. Who is the human checkpoint between this answer and the irreversible action? If you can't name a specific person, a lawyer, a senior engineer, a compliance officer, who reviews this output before action, you do not have a workflow. You have a single point of failure with extra steps. Question 4. And this is the one that would have stopped Krafton cold. Discoverability. If this entire conversation appeared on a screen, in front of a judge or a regulator or your board or a journalist, are you still proud of the question you asked? Are you still proud of the way you asked it? Because it might. The Krafton CEO did not run that question. He found out the hard way that every prompt is potentially a piece of evidence. Adversarial, jurisdiction, verification, discoverability. 4 questions, 30 seconds. Saves you $250 million. Here's the thing. Nobody who covered this story is going to tell you. The actual lesson isn't about ChatGPT, and it isn't about Krafton. It's about a structural mismatch between two things: decision velocity and decision weight. Large language models are unreasonably good at speeding up decisions. You can move from problem to draft answer in seconds. That is genuinely new in the world. It feels like leverage. It is leverage. But large language models are structurally bad at weighting decisions. They give the same confident, fluent, well formatted answer to what should I have for lunch and how should I structure a corporate takeover. The interface does not change. The hedging does not meaningfully change. The model has no sense of which decisions are recoverable and which decisions are seen by federal judges. That gap between speed and weight is where every operator now lives. And the people who win the next decade of AI are not going to be the people who use AI the most. They're going to be the people who design the cleanest checkpoint between AI output and irreversible action. Builders who add a verification layer, operators who add a 4-question test, founders who treat every prompt like it might end up in court, because some of them will. If you take one thing from this video, take that. The leverage is not in the answer. The leverage is in the gate between the answer and the action. So, recap. ChatGPT did not lose this case. The Krafton CEO lost this case. The 4-question test would have flagged every move. The cost of skipping it was $250 million and a permanent slot in business school case studies. If you want the 1-page version of what we just covered, the 4-question test, the 3 failure mode checklist, and the 5 high-stakes domains where you should never act on AI output without adversarial review, drop the word prompt in the comments. I'll send the PDF directly. It's free. If this changed how you think about building with AI, hit subscribe. That's how the channel grows. And share it with the operator in your life who is one prompt away from doing something they cannot undo. I'll see you in the next one.